Right, gentlemen, I have reviewed the relevant laws and I've looked at the statutes, including relevant authorities on this area, and this is the ruling of the court. I've listened carefully to the pleas of the defense counsel in this case, seeking a date for the accused person to report to the election. This is a criminal trial and the applicable laws and procedures have to be followed. I've had regard to section 192 to section 194 of the Criminal Procedure Act 1965, which requires the accused person to report to the election at the close of the prosecution's case and not after the prosecution's case or after a no case submission. The submission of no case is separate and distinct from the requirement of the accused to indicate to the court as to how they intend to conduct the defense. The court is also open in appropriate circumstances in the interest of justice to allow an accused person to amend their election if they so choose. This case has been in the courts since November 2021, and the lawyers for the accused have had a sufficient time, as demonstrated by the extensive cross-examination to which witnesses were subjected to have decided what to do at the close of the prosecution's case. To require time simply to determine what to do at the close of the prosecution's case, or in fact, after the prosecution's case and after a no case submission, when the prosecution's case became closed on the 12th of December 2022, is inimical to the interest of justice and the circumstances the accused persons would be put to their elections immediately. I've also considered Article 549 of Article 36th edition, which requires such an election to remain at the close of the prosecution's case and not after the prosecution's case. And upon a review of the relevant authorities, the election is akin to taking a plea, and time cannot be given for the taking of a plea upon the arraignment or appearance of an accused person. In circumstances that will always follow, the accused will be put to the election and may be advised by the lawyers if they so please. I'm satisfied, secondly, that ample time has been given for that decision to be made, having regard to the 30-minute time down that I have already taken and the length of time the proceedings have so far been taken to reach this stage. That's the will of the court. Right, Mr. Nalo. Stand up, please. Now, right, Mr. Nalo, the law requires that in a criminal trial, I must follow the law to the letter. There is no room to short circuit or to change the laws. I've got to follow because any non-compliance with the laws can create problems. So, in that regard, the law requires, under section 192 to 194 of the Criminal Procedure Act, that at the close of the prosecution's case, I need to put you to your election. That does not mean that you have to start your defense immediately. It simply means that I need to tell you what your options are and to get an indication from you as to how you intend to conduct your defense. Now, in the area of witnesses, you don't have to tell me at this point how many witnesses you wish to call, if you do wish to call witnesses. But suffice to say, I need to know if you intend to call witnesses, and then of course the court then gives you time to determine when those witnesses will be called. Do you understand what I'm saying so far? Right, so I need to comply with what the statute says, which is the Criminal Procedure Act. Okay? So now you're free to confer with your counsel to ask him what should I do if he has not already told you. But these are the options that you have available to you. Now, you remember that back then when this case started, you gave a statement to the ACC. You know that statement? Alright, and that statement has been tendered in this court. It is before. So you can decide to say, okay, I'm happy with what I've said in that statement, and I have nothing more to say. But I'm going to call witnesses. Or I am not going to call witnesses. Do you understand that? Yes, sir. Alright. So that's option number one. So keep that in the back, and then we'll come back to you later on. Okay? Alright.
Now, just a procedural issue. We see that like the cameras are still on the court. We don't know whether the cameras participate while the trial proceed. Because you give your ruling has finished, and then the cameras are still in court. So we just want to get it's a criminal trial. So we don't know whether the cameras are allowed to hear while the trial is going on out there, because the will has been given and that's submitted.
The Constitution requires a criminal trial to be held in public. So nothing wrong with that.
Full-fledged studio and equipment, and as accused persons, whether we can also make our equipment court to
make the application as well. Right. So, Mr. Allen, you understand the first option that I gave you? Okay. All right. Now, the second option, where you are right now, you can just stand there and tell me everything you want to tell me about the case. Okay? I will listen to you, I will record all of it down, but then nobody will ask you any questions. Okay? So you will just explain what is going on and we will still consider what you have said. So that's the second option that you have. Okay? Now, the third option you have is you can decide to say, I'm going to come into the witness box and I'm going to testify in when you come to the witness box there, I was examining witnesses for the prosecution. Do you understand that? Right. Now, there's something else where you are and just explain about the case. The weight that I will put on that evidence will not be as if you are in the witness box, for the simple reason that that evidence is not tested by cross-examination. So I will listen to you, but I might believe you, I might not believe you. Alright, that is what that is for. Now, if you come into the witness box here, where you take one of those books, you swear on them, and then the prosecutors ask you questions, the law requires that I evaluate that evidence in terms of whether I believe you or not in the same way that I evaluated the evidence of witnesses for the prosecution. So, in other words, I look at it and say, well, I believe what Mr. Naro is telling me, and I disbelieve what the prosecution witnesses have told me. Or alternatively, I can say I don't believe what Mr. Naro is telling me, but I believe what the prosecution witnesses are telling me. But essentially, you need to understand the difference between the two. That we will still record where you are, we will still record in the witness box, but the evidence that you give in the witness box will carry more weight than one that you give standing where you are. And then with all three of those options, you have a right to still call witnesses or to decide that you are not going to call any witness. Okay? Do you understand those points? So these are the three options that you have. of which the law requires that I address it to you and ask you to make a decision, of course, subject to whatever advice your counsel gives you. You understand those, yes?
You're giving me 3 options. Is it the case that I will choose all 3 options or that it is only 1 or 2?
No, you only have one out of the 3. It says A, B, or C. Because that's the way the statute, the Criminal Procedure Act says you should go about it. But with all 3 options, you have a right to call witnesses. Even if you're coming into the box, you can call a witness. Even if you're just relying on the statement which you gave to the ACC, you can call a witness. If you're standing there, you can call a witness. Alright? But you only have one main option and then the witnesses can come in.
Yes. Thank you very much. The instruction of the client is that.
No, I can't tell you. It is should come from here.
Yes, no, I was just going to say that it's ready to be put to the election.
Yeah, but it has to come from here.
Yes, he's ready to do that. That's what I said.
Okay. Mr. Nalo, again, I need to make sure. Have you had advice from your lawyer?
I'm not about the lawyer.
No, I just want to know that. Have you had advice from him? Yes?
I know, I didn't say this right. I want to let you know that right from the beginning, I didn't go to my solicitor, but I'm ready to take the case first. Thank you very much.
Okay.
And I call this.
And call witnesses. And let me just let you know, as I've just said, just to remind you, that your evidence will carry the same weight as the evidence given by prosecution witnesses. So it doesn't mean I treat your evidence any less than I treat their evidence. Alright? Yes, you may say, thank you.
And with further caveat that subject to what comes out of the process.
Yes, and this is in the ruling that should there be a need to change elections as a result of the law constitution, sure, what is open to that?
As your lordship.
Right, Mr. Sumas, time please. Right. Mr. Sumas, I know you had this call before, but the law says I need to tell you. Alright? In a criminal trial, we must follow the law as it is. There's no room to change things around. Okay? So, what the law requires is that at the close of the prosecution's case, I must immediately put you to your election. Now, there's been a notice submission which has taken some time to complete, but notwithstanding, the law requires that I do that. This is the Criminal Procedure Act. Okay? So, having said that, the law says I should ask you and give to you 3 options that you pick one of those options. Now, option number 1, you can stand where you are and just explain everything you want to explain about this case. I will note it all down, and when I come to consider a verdict, I will look at it, I'll take it into account with all the other evidence that is before the court. Okay? That's number 1. You understand that option?
Yes, my lord.
Okay. Now, option number 2, you can decide to say, I gave a statement to the introduction at the start of this case. I'm happy with that statement. I've got nothing to say. Because you do not have to prove anything. It is the anti-corruption that have to prove their case against you. They have the burden to prove the case against you. So you're not obliged to even say anything in this case, but it's a matter for you. So you can simply rely on the statement that you gave to the ACC and say nothing more. Okay? That's option. Take one of those books, you swear on them, and then you give your evidence in the same way like the other witnesses for the prosecution have done. Now, when you finish giving that evidence, the lawyers for the ACC will ask you questions in the same way like the lawyers were asking questions of witnesses for the prosecution. Do you understand that? Yes, okay, now there are benefits and demerits to both coming into the witness box to testify on oath and to stand where you are and just tell the court anything you want to say. Now, if you stand where you are and just tell the court everything you want to say, I will not give it as much weight as I will give it to the evidence that you give in the witness box. So I will listen to you, but then I might decide, well, I don't believe you anyway, and I just ignore it. Now, if you come into the witness box and you testify, because of the fact that the prosecution will be asking you questions, the law requires me to take that evidence in the same way like I would take the evidence for witnesses for the prosecution. So I'll look at what you say and I'll compare and contrast backwards and forwards until I come to a position on it. Okay? So you understand those three options? Yes, sir. Alright. Now, the other option that you have is you can call witnesses. Either option that you choose, A, B, or C, you can call witnesses and say to them, look, come and testify for me. You don't have to tell me how many witnesses you have now. But you can simply say to me, I think I'll be calling witnesses. Okay? Now, down the line, when we come back from New York, if you think that, well, what I said to the court earlier wrong, I want to change my mind, you let me know, and then of course, I will give you an opportunity to change your mind if that's what you want to do. The law allows that. Okay? Now, again, the statement that you've given to this ACC, you can rely on that and then say, well, I have a witness or I don't have a witness. So, do you understand those three options? Yes, my Lord. All right. Now, before I hear from you, you have an opportunity to confer with your counsel, ask for him to advise you as to what you need to do. And before you speak again, I'll ask you if you've got that note of advice from him. Alright? Yes, yes.
Having looked at the authority section 192 section 1, as long as the accused is defended, it can't be done by the counsel.
No. The accused is put to his election.
No. As long as the counsel.
No.
I go through the.
I have gone through it, that's why I went to tell I've looked at the authorities. No, the accused wants to put to his election. I'm not it's not just 194. 194. No, I'm told. I'm not going to say the accused can get advice from counsel, but it is his trial and he needs to decide which way he wants to decide.
As long as he is the accused is defended, counsel can do it.
No, I'm looked at the authorities as well. That's why I'm going to say it. The several authorities on the point. It is the accused that is put to the election. I know what you say in the CPA, but 192 to 194 gives the accused the right to put to the election.
The authority 192 is very clear on this point.
You know, just several case law. Right performance.
This is the authority, the right.
No.
It's where
No.
accused is unrepresented.
No.
That is where
I am going to say no. I'm not going to give you I'm going to say no.
you're not making it out that you need a
Yes, I'm going to do it.
Are you taking on the objection?
No, I will not give you because I'm going to do it.
I did not make my objection and
No,
allow me to
I will not give you because I'm going to do it. I'm volunteer, I'm looking at the
make the objection. Allow your good.
I said no. I'm not going to give you. No. No, I'm not going to do it. All the authorities that I saw from the Supreme Court down to the Court of Appeal and the High Court required the accused to report the election. You can fight it the same thing. Doesn't make a difference.
Yes, but I can do it for him. He's represented.
No, I know, but the accused must be put the opening salvo is the accused must be put to the election.
I'm your counsel who is representing you.
No.
Can this or answer question section 191?
I'm going to leave. I'm not going to
You
do
don't
it.
make the application.
I ruled on the point I have had. Whatever was said, I went upstairs. I took the CPA, I ruled on it, and that's it. No. No. I ruled on it. No. The law is very clear on that. I ruled on it. You know, the accused is here, you can speak for himself, the counsel goes along.
The authority is here. This is my view.
And the Supreme Court has decision of that.
You not see your ruling. You not see your ruling.
No, I'll finish with this. Yes, Mr. Suma. So, Mr. Suma, I'm saying you're free to consult with your counsel on the options that I have given you. But the law is very clear that I should hear it from you. That's why I'm writing it to you. Okay? Yes, my lord. Right, Mr. Suma, again, the law requires me to ask you, on what was of subsection 23, have you conferred with your lawyer? Yes, my lord. Right, and of the three options that were given you, which one do you intend to take? My honor, I elect to pursue the third option and call witnesses. Yes, no, all of the three options that you have, you can call witnesses on all of them. I elect to take the witness box. You have to take the witness box. Yes, perfect. But let me just remind you again that when you testify in the witness box and you take one of those books and you swear on them, the evidence has the same weight as that given by prosecution witnesses. Yes, right? So I look at it in the lab. And then you say you're going to call witnesses. Yes, okay. All right. Thank you very much. You can see it. Yes, sir. Mr. Bawo. I know you have what I've said, but I still need to go over it again with you. Okay? Now, the law requires that everything we do in a criminal trial must follow the legal process. So, the CPA, as the Criminal Procedure Act, requires that at the close of the prosecution's case, I must put you to your election. Okay? Now, in putting you to election, you are simply indicating to the court what you intend to do as part of your case. Now, you're free and you have the right to confer with your lawyer at any stage. So whatever it is you say, you do it for legal advice. Okay? Now, you remember when you started off with this case, you gave a statement to the ACC. Now, that statement is already before the court. So you have a choice. Okay? You can rely on that statement that you gave to the ACC, and then you say, I have nothing more to say. I'm just going to rely on that statement that I've given to the ACC. So that is option number one. Do you understand that? Okay. Now, option number two, you can stand where you are as it is, say nothing whatsoever, or in fact explain everything you want to say, or just whatever you want to say, you say it. I will note it down, but then I'll listen to it, but I'll take it into account as part of the overall case. That's option number two. Okay? You understand that? Right. Option number three, you can come in here and then you say, okay, I'm going to pick one of those books in there, Bible or Quran. I'm going to swear on them and I'm going to tell the court exactly what happened. Now, the law requires that I should give you equal weight, like I gave to the prosecution witnesses. So, in other words, their evidence is not better than yours. I'll consider it in the same way like I will consider them to determine one way or the other who I believe. Okay? But when you finish in that box, the state lawyers will have to ask you questions. So the court examine you in the same way like your lawyers have been cross-examining witnesses for the prosecution. You understand that option? Alright. So now, the difference between the two, that is you standing where you are and telling me anything you want to tell me about the case, and coming to the witness box, means that when you stand there, I don't place much weight on it. I'll simply listen to you, record it, and if there's something there that I believe I should pay attention to, I will. Because the reason being, questions were not asked by the prosecutors. Okay? But if you go in there, it's different issue. So those are the three options that you have. Okay? On those three options, A, B, and C, you have the right to call witnesses if you want to call witnesses. So you can say, you don't have to tell me now that you have 5 witnesses or how many witnesses. I have witnesses which I will call subsequently. Okay? So do you understand those three options? Alright. Before you tell me what you want to do, you have a right to confer with your lawyer to say, well, what do you advise me to do? And when you finish, I'm going to ask you again whether you got legal advice. I don't want to know what your lawyer told you, but just tell me that yes, I've got legal advice. Okay? So you understand those? Mr. Telecom, I think you should be planning what to do.
Yes.
Okay. Okay. Now, Mr. Bob, have you had legal advice from your counsel? So, of those three options I've given you, what do you intend to do?
With the provider stuff, I have witnesses who are not.
Sorry?
I have witnesses, I have plans to get witnesses from America. So I try to request from the court to fund their trip from America to Canada.
Right. Now, your witnesses do not need to come here because we can arrange video links. where they can testify via video link. So it saves cost. But when we're done, the registrar will tell you what to do. Alright? Now, you say you have witnesses to call, yeah? Alright, thank you very much. Right, Dr. Kamara, good afternoon. Right, in every criminal trial, the law requires that we follow the law to the letter as it is, which means that at the close of the prosecution's case, the law requires, as the criminal procedure act, I should put you to your election. In other words, I should inquire from you how you intend to conduct your defense in this case. Alright? So that is what the law requires me to do. Now, of course, you're represented by counsel, so you're free at any stage of the process to consult with your counsel and get legal advice from them. Okay? Alright, so now, remember when this case started off, you had statements taken from you at the ACC. Alright, so you can look at those statements and say, okay, I've given those statements to the ACC, I'm not going to say anything more. Because it is the prosecution of what you hear that have the duty to prove your guilt in this court. You don't have to prove anything. Okay? So you can simply say, I've given my statement and I say nothing more. Case closed. That's option number one that you have. Okay? You understand that option? Okay. Now, option number two that you have, you can simply stand where you are and say, okay, you know what? I need to explain what has been going on. And then, however long it takes, whatever you want to say, I will record everything that you're saying to me. And then you can say, okay, I've said all what I want to say, and that's it. I leave it to that. Okay, that's option number two. Now, option number three, you can decide to say, you know what I'm going to do? I'm going to come into this witness box. Because I want the court to hear from me as to what happened. So you take one of those books, Quran and Bible, you swear on them on both, and then you testify, just like witnesses for the prosecution. So essentially, you'll be allowed to say your counsel will be asking you questions, and then you explain what you want to explain, and then when you're done, the lawyers from the prosecution will ask you questions. So that's option number three. Now, I need to explain to you the two options that you have. Now, if you stand where you are and just explain to me whatever you want to say, I will listen to you. I will record it, but then I might say, okay, yeah, well, I've had enough. I know that. You okay? I am. Okay. So I might just say, okay, I listened to you, I heard you, and that's it. But if I say something that maybe is important, I will listen to it. But then the weight that I give to it is not like the evidence that is given in the witness box. So, if you are in the witness box, even though you are accused, but your evidence carries the same weight as the prosecution witnesses that testify in. But the only thing is, the prosecutors here will ask you questions. Then we can assess the evidence one way or the other. So these are the three options that you have. Now, amongst those three options, you can call witnesses that will come here, take the oath, and then they will testify on your behalf. To say, oh, doctors don't do this, or whatever it is they want to tell us. And then when they finish, the prosecutors here will ask them questions. And then we will take all that evidence in the round and consider it with whichever option that you choose to determine how to go about the matter. Okay? So the important thing here that we need to remember is there are benefits of taking one option and there are demerits of taking another option. But then what you will do, you confer with your counsel who will advise you as to what you wish to do. Okay? Now, when you're done, the law requires me to ask you again if you have the benefit of legal advice. So you understand those options? All right. So you're free to confer with Mr. Kari.
Thank you, madam.
So, Dr. Kamara, have you had legal advice? Don't tell me what he told you. I just need to know if you had legal advice. But you have conferred with a lawyer.
I wish I had more time.
Well, you still, let me say, you have the option down the line. I'm open to say to you if you feel that, well, that option that I chose, I don't like it, I can change it. I'll give you that option as well. Because we have to go to New York, and when we come back, you might choose to change your mind. But just so I have an indication of how you intend to conduct your defense. All right? Okay. So, what do you intend to do?
I will testify. I'm calling witnesses all the time. From the Lord.
So you come to the witness box to testify as a witness in the case.
That's how my release.
Okay. Now, just so you know, that evidence that you give is the same. We're not looking at you as an accused when you're in that box. You're a witness like everybody else. You understand that?
I know that.
Okay. All right. Thank you very much, sir. It is it. Right. Mr. Senator.
Yes.
To try to tonight.
Yes, we are calling you. And I'm informing you.
All right. Mr. Kamara, Dr. Kamara, sorry, can you hear me? So not you, Dr. Kanye is actually using Kamara.
Yes.
Can you hear me what I'm saying? All right. But can you hear me now? All right. Now we are at the stage of the proceedings where the law requires that I need to put you to your election to decide how you want to put your defense in this case. Do you understand? All right. So the law says that I should give you a number of options. Now, I'm going to give you those options, and I'm going to explain to you what those options mean. But when I'm done, you are entitled to confer with your lawyer to get advice from him as to which way you intend to go. Do you understand that? All right. Now, option number one, you remember when this matter started off, the ACC did take a statement from you. Remember that? Do you remember giving a statement to the anti-corruption? All right. So, option number one that you have is you can simply say you're going to rely on that statement that you gave to the ACC and you say nothing more. That's option number one. Do you understand that option? All right. So keep that in the back. Now, the second option you have is you can swear on oath, take one of those books, Bible of Quran, and then we'll get a video link out for you to make sure you have the Bible and the Quran, and then you can testify in your own behalf. You understand that? Alright, and when you finish, whilst you're doing it, your lawyer will ask you questions. And when you're done, the lawyers for the prosecution will ask you questions again. Do you understand that? Alright. Now, the other option that you have, which is the third option that you have, is you can simply, like you're talking to me now, just explain anything you want to explain about the case. You understand that? Alright, I said you can simply explain to me, like you are right now. Tell me anything you want to tell me about this case. I will listen to you, I will note it down, but then that's about it. Because I will not be able to give it a lot of weight because it has not been tested in court examination. You understand that? So the benefits and the demerits of the two of them is, if you just tell me anything you want to tell me about this case, I might not take it in the way I should take it if you're testifying on both. Simply because the evidence that you give on both will have been tested in court examination, so you will be treated as a witness like all other witnesses for the prosecution. Do you understand that? Alright. Then, of all those three options which are given to you, you have a right to call witnesses if you wish to. Do you understand that? So either option A, B, or C, you can call a witness to come to court here or to testify via video link on your behalf. Do you understand those three options? Alright, so now you are going to be free to talk to a lawyer who will advise you what to do. But then when you're done, I'm going to ask you if you've had legal advice from a lawyer. Do you understand that? Yes. Alright. So you're free to talk to your lawyer. Sure. Alright. Dr. Kamara, can you hear me? Alright. Now, have you had legal advice from your counsel? Alright. So, of those three options that I gave you, which one of those options would you elect to choose? Which is what? Which option? Which of the three? Tell me. Now, do you have any witnesses that you wish to call? Do you have any witnesses that you wish to call? Are you saying you may call witnesses? Alright. Now, what I want to say to you is this, that in as much as you've chosen these options now, you're free, following the visit in New York, to change your mind. And I'll accommodate you in that, okay? Alright. Thank you very much. Right. Just so councils are aware, the locus in co visit is likely to be done between the 1st and the 8th of March. The 1st and the 8th of March. So preparations are actively in hand for that period. And I propose to bring this matter back on the 17th of March for the start of the defense case. So anyone that has witnesses, I think we should be getting the witnesses ready. If obviously, depending on what happens in New York, what we see in New York, people might change their minds. I don't have a problem. But the only thing that I would say is if there's going to be a change of mind after New York, please do an application quickly so we don't waste time. So I know there's going to be a change of mind, so then I can adjust the dates one way or the other going forward just to deal with the question of election. But the defense case will start on the 17th of March. Anybody have any issues with that?
I'm not with that, but my parents haven't taken big to his election. They was trying to inform the court and the defense, all the witnesses for my advice, my lord. But it is clear that the witnesses will be calling are all in the United States of America. And we really love to actually have them in person so that the judge gets to see the examination in chief and the cross examination therefore study the demeanor of the witnesses as is often done and or as it was done with the prosecution witnesses.
So I can't see them on video.
Now, I would just love the court to follow the trend. I mean, the prosecution, there were times it took like a month or two just waiting for one witness to come from abroad to come and testify. If my memory serves me well, one particular witness we had done for over a month or so, because the court really wanted to see that witness in person. I take the view that we are fastly trying to go technological, but as defense counsel, I would be more comforted if this witness, we have to take the witness and examine him in chief.
So are you prepared to pay for him to come in?
My lord, that's why I'm asking the state, my lord, because it's justice, my lord, justice for the appeal and justice for the prosecution. My client has not been working since he was indicted in this matter. He's not been working, he's been on 50% of what he used to earn.
Well, now you see, Mr. Guevara, why that's another reason why I want this matter over and done with. Because it's certainly not fair on somebody if they're going to be acquitted to actually be suffering for months and months and months and months until the matter is finished. But if you're saying to me that
and it's not telling that you are 800,000.
well, absolutely, and nobody can survive that.
Yes.
So that's one of the reasons why I sit and think, well, I would not want to be in the position that they're in. So this matter needs to be dealt with. People because already they've lost a lot by being in court. So we cannot ignore that. But that said, if you're saying to me that you want witnesses to come here, then you need to give me the legal basis for the state to prove the bill.
And we will endeavor to justify why the state should. And if you look at our jurisdiction, we operate on a legal aid basis, particularly when an accused person is impecunious. I was speaking from the bar and doing this matter pro bono because this accused person cannot afford my services.
But let's go abundantly.
Yes. And I was because he cannot afford my services, he definitely cannot afford the means of flying the witness from America to come and testify as he's here. Without all the reasons why the state being a person is interested in justice for the state and justice for the accused under its peace. The accused is under the peace of the state. That the state should afford us the opportunity by funding our witness to fly in and come and testify. Now, the criminal matter of this nature is something I mean, we take very serious as effect, meaning because we all know the end product of it. We know the end product of it. You know, if you get the sweetest word in the world, not guilty, you go sleeping. If you get the most sad words of guilty, your entire life is put on the hold. So there is no amount of financial investment that will match human liberty. And that's all the reason why I am pleading this government to afford us the opportunity to present the best of defense in this case.
Well, let's put it this way. I can only imagine that Mr. Maximo might have something to say about it. But what the law does require is if you cannot afford to pay for a lawyer, the state will pay for it. But then you have to convince me that the law should be made to pay for a witness to come and testify in your case. But there's no reason for it.
In the same vein, I am not sure there is precedent for lawyers for the defense to be funded abroad for a low-cost income. But on this case, taking the exigency or the importance of the case, the state is going to be funding defense counsel because the accused person is impecunious upon his own.
No. The difference with that is that lawyer is going to carry out legal representation all in New York. So the state must fund that. But as to calling a witness and say, well, come and testify with me, and then the state should pay for that, there are no precedent for that.
Now, the question I would love to ask to the state is just if this witness cannot afford to bring his witness to testify, and as a result of his failure to bring a witness, he's convicted.
Well, that is why we have to video it. I can look at the witness, I'm able to see what the witness is saying, I'm able to assess the demeanor in the same way. Like I look at the witness if he's standing across there.
So I take the point.
But not to discourage you, Mr. I would say, if you remain passionate about it, file a motion asking the taxpayer that the state fund the provision or the facilitation of a witness from the United States to Sierra Leone and back. And then, of course, it gives the state the opportunity to respond, and I will roll it. That's the best I can do. I guess you have something to say about that.
Preliminary observation. There seems to be some confusion rather as to the state and the prosecutor. I am fully aware that we will really prosecuting the name of the state. But when it comes to issues relating to legal aid, and it's not really the responsibility of the prosecuting authority.
It is the state. That's what the Constitution says.
Yes, the state, but not for clarity, not the agency.
Therefore, you are representing the state.
Yes. If their mechanism, their voting that are set out specifically for that, it doesn't have anything to do with the prosecutor. Whether it's the state.
No. It is not you per se or as in the ACC should deal with the board. If an application is made, which I believe is the department is talking about, it's a matter for you to then pass it on to the state that you're representing. To say, I have this application before me, counsel for the accused is asking for a witness to come here, and then you take instructions. Because you represent the state.
Would it be faster, so to speak, if they approach the
could not effectively cover that inquest that is happening. What is happening here is we're in the middle of a criminal trial, and he said, well, as part of my defense, I need to have a witness here, but I can't afford to get that witness here. So it is for this reason why I said to him, you need to file a motion seeking the state to pay for that witness to come over here. You will have an opportunity to file an affidavit in opposition, and I will rule it as the best way forward in the interest of justice.
Yes. Is that obligation that
No. The issue is the onus is on them to show. That's why I told Mr. Gebau to tell me the basis of his application and to put it in application. So then I see the legal basis of his request. But as far as I am concerned, I can see the witness by videoing. Now, COVID has got to the point where we can see people across the world. So if he's saying he wants to see the witness here live, it is to give a good reason in the motion. So, and of course, you will have an opportunity to respond to anything in the case. So this is where we are. This is why I haven't said anything about it until she files, and then you have to explain the reasoning behind this filing. And of course, if that is the case, then arrangements can be made, or if there's a ruling to the effect that the state should pay, then we'll take it from there. Yes, right? Okay.
And in that regard, there are also very positive awareness was given of us to be done. So have our friends on the other side assist in securing this.
Well, I think that's subject to the previous ruling, but then I also gave a ruling yesterday, which I ordered the master to forward into the foreign affairs and to get necessary applications of that. You want to copy of the ruling, the shall be to you.
Yes,
but that was sent yesterday.
Okay. The next issue is whether cameras are now a permanent fixture in this court, this trial and so on. Because
you also have your
we have our own estimate that will not be given the opportunity. And we broadcast, we really broadcast worldwide.
Well, look, put it this way. A decision was taken that this ruling for transparency of the judicial is to be broadcast. As to what happens after today, I cannot say. But in view of the fact that you have your own media, I would suggest you guys in order to change justice, and we want to also come and work out. And of course, if you give the go ahead, I'm sure your media will be here too.
That's normal nowadays.
Yeah, but I think trials like this, my view is that they should be broadcast. That's my view. That everybody should be able to sit in the comfort of their homes and observe what is going on in the court.
That's very powerful that people across.
Well, whether that might be, I don't know. But what I know is a trial should be published so people get to know. I mean, you have court TV in America. So, I don't know why we should not have court TV here. Yeah, it's like the CBI will ask him, say, look, I have my own media. What is the media? I don't know. But I'm sure it will continue. But for today, the camera is not here for today. Yes, I've got nothing else to say that they will be here on this occasion.
And that's a landmark.
I mean, we just have to deal with it, and to let the public understand what's going on.
But we all still need to perhaps emphasize the fact that nobody has been convicted, nobody has been found guilty. But for us in the political arena, you know how these things can be twisted.
No, yes, and I entirely agree with you, and this is why you have noted that at the start of this meeting, I indicated that at paragraph 5, that nobody has been convicted. This is not about guilt or innocence. It's simply about whether the prosecution has established a case. And that's why I went into the lens to say, at the end of the day, the prosecution might not establish a case. So nobody should be going out there to say, oh, guilty, not guilty. No, we'll not reach that stage.
Much of that, sir.
No, and I'm sure members of the press understand that we've not dealt with guilt or innocence today, and I don't want to see anything about guilty or any of that in the papers. But I'm not worried about the papers anyway, but I'm worried about the social media. You know, and those who are in the habit of giving out misinformation on social media about people being guilty when they're not been found guilty, if you're caught, you know, it will be nice. So I hope people understand if you're going to make comments about the case, be accurate. Nobody has been found guilty. We're just here to look at what the evidence that the prosecution has given. I've been very clear that the test we used was not beyond reasonable doubt. Just a basic test that is there a case, is there a case. We'll continue. I think those who are wise enough to understand that.
Lastly, on behalf of the defense, we want to have hard copies of the either hard or electronic copies of the school side.
Sure, you get hard copies of it. It won't be today. I would love to do that today, but it'll be tomorrow. So if you have a talk with the Anne, is there? Yeah, if you have a talk with the registrar, you will get copies of it, and then I might look for those who supply by email for these copies. But I'm not promising, but I just might.
But I will take it now that it's adjournment to a week's time.
No, that's a different thing. We're back on the 17th of March for the defense case, and in between now and the 17th of March, notification will come out, we need to go to New York and come back. And when we come back from New York, if there's any application that needs to be made, is to give out everything about you. You need to make that application, so we'll deal with it before the 17th. I will not come on the 17th and say, oh, you know, I have this and that. No, let's deal with it. And Mr. Martin, the same applies to you as well. If there are any issues that you wish to raise after New York, I am not going to open my case or I seek to, I need to have those motions before the 17th so I can deal with them. Alright? But if they are known, that's fine. You come, the defense starts their case, and that's it.
Just one other matter.
It's a bit sensitive in the sense that these are issues that we have been dealing with a bit of discretion. I.e., we have made reference to prevailing setups. Every one of us knows what those are. But when anything with the greatest of respect, there is made a statement which might be interpreted otherwise.
What statement?
When we made the indication that accused number 4 will be the next president.
Why you guys answer me?
Can I be allowed to finish my
please, gentlemen, please, come on, this is a go. Now, hold on. Look. Let's not descend this place into some gutter or junk. There's a simple, the lawyer is an issue is saying something that concerns him, right? And is addressing to Mr. Kabu. I expect to hear only from Mr. Kabu. So please, let's just come into the dialogue. Mr.
For one or two reasons, I've kept quiet throughout the day. But I found it unnecessary for the statement to have come from my learned friend for whom I have the greatest of respect. My Lord, this is a court of law, and this is a criminal trial. And nobody is above the law. I know that only His Excellency the President, whilst in office, cannot be brought to justice. My Lord, my learned friend, Masibo, and I whispered together that making that statement might send the wrong message. And I have seen, unfortunately, a demonstration, not by the public, but our colleagues, who, when this, my learned friend, made mention of the fact that that was necessary. It was jumped at. My Lord, I never like to go into political issues. I've always kept the distance. But my Lord, the public is there. And some members of the public may see us as not doing our job, but going after their leaders. So I think it behoves all of us to, especially when we are to maintain an atmosphere that will not send the wrong message. I know that perhaps I'm back on in age, but I would like to lead this world in a peaceful way. These are not normal circumstances. We all know what the circumstances are. But I would plead that we keep the political issues out of court. Thank you.
Thank you, my Lord. First of all, let me start by assuring Mr. Nancy that the gentleman dealt with the president of Zimbabwe. And in terms of trying to put a fetter on council, that can only be done by the lordship. And when I raised the issue, Lord, it was as harmless as the way it was brought up. For our learned police on the other side to take coverage, I think it's unbecoming of the prosecuting bar in this case. I don't think that issue is in doubt, Lord. We are confirming reality here. But I think
No. I think Mr. Kabu, on a serious note, I think the considerations that Mr. Mason raised are serious. You see, we have people who are very gullible. We have people who believe what they want to believe, regardless of what the truth is. This is the court. So far, I've tried to maintain the trial on the law and not on any other consideration. And I'm going to continue to do that. But in the same time, we have to bear in mind, which I said, I bear in mind what is going on outside. But that does not mean that we need to feel the anxieties and the excitedness that is going on outside. Because what we certainly don't want to do is to politicize the course. You are very senior counsel and you know as well, even from your time as Attorney General, that the court ought not to be politicized. So it's not a political trial. Yes, we have regard to considerations outside, but we're simply looking at what is before us by way of evidence. And that is the message that I prefer to see outside. Whatever happens outside, that's an issue for another day. It's not considered information for the court. So we need to be careful about our utterances because then after some listen quite clearly pointing out, there are people who will misconstrue what you said. I did not say anything because I knew it was just an excited utterance from you. So that's why I just focused on the case. But there are people outside who will not understand that it's an excited utterance. So please, let's leave the campaign outside of the courtroom. Let's focus on the law and what is before us. I think that will help all of us.
You know, I take your admonition to do that. And I assure my friends that as long as we keep on the straight and narrow, we'll continue in the
We are not going to politicize.
No, you're right.
So we leave it out of it. That is why, let me make it clear. In fact, one of the instructions that I gave this morning, and I'm not going to share with you that, is that I do not want to see people clad in political affairs in this court. Political garment. I said it very clearly. Because I was against it, I want us to all be in here. You as lawyers have an opportunity to represent your client in the best possible interest. But what I don't want to see is political garments in the courtroom. Because then you're going to have other callers coming into the courtroom and it's chaos. So we should remind you of that.
As as I say, I take your admonition to do that. And
let's focus on the law.
we'll make sure that we focus on that.
Let's focus on the law. This is a serious matter, and we don't want to get distracted by what is happening elsewhere. And the public needs to understand that here we're looking at the law. There's nothing else we're looking at here other than what is before.
Certainly, I'm going to address you just on the law.
Yeah, let's just come to the law and the facts. Yeah.
Absolutely.
Well, you see, at the end of the day, I always believe that when an accused is appearing in the court, they need to have the best possible defense, which means a defense that is focused on the case. Because if you're not, then you need lapses. So this is where I want us to focus on what is before us.
We'll do that.
Please, I appreciate that.
Thank you, Lord.
Thank you. So, listen, I believe that article deals with your concerns. Thank you.
Sorry,
Yes, it's a program.
yeah, now that this local visit will be coming up and we're not coming back to us before the visit, I was just wondering if Mr. Jules Sanders will inform because there is a possibility that the court will have to constitute itself at the locals. And Jules Sanders, I mean, he's an accused person before the court. And the court is moving to the jurisdiction of the contract. Your Lordship didn't want to say anything about that, but I think it is crucial because if it is possible, we probably might want to have him as a witness at the locals. So that we lead that issue to the court.
Well, you see, you just encourage the last Mr. Basu, but you go up there. That's why in the notice submission, I recommend the fact that Mr. Sanders is free to come to the trial if he likes.
So it's about informing him.
Yes, he will be informed. He will be informed.
I don't think Bernard has anything to object to about that.
He's accused. He's just not before the court, but he's accused.
My only objection would be whether this court can be constituted in the US.
The court can be constituted anywhere. Even the court can go to the local.
My understanding is the jurisdiction of this court ordinarily is limited to the geographical.
No.
Indeed, my lord, only in instances where, for example, offenses are alleged to be committed within the embassy or the.
No.
So I see that he has no business speaking on there. He's fully aware that he has no business speaking on
I'm saying there's you will be called. You will be called. Not going to go. that a British judge came here and conducted a trial here. Quite recently.
Well, yes, the trial was conducted here.
So likewise, this court can move to New York and conduct a trial in New York. It is still the court of surveillance in New York. The court can sit anywhere. As long as I am there, I call counsel, the court can sit.
Especially it's within the precinct of the church.
That's right. And in fact, the church is built in Sierra Leone.
Yeah, that's the thing I was getting.
Sierra Leone.
Because we need some national.
Where were you from? This is where you go.
That's why you're there. There is a possibility to, Mr. Masimo, there is a possibility to prepare Dr. Ali Kaba for a report on the country.
Certainly, I mean, every business I've said is open. Anybody that wants to change that can file an application and then I will rule on it. It's as simple as that. Alright? So I think all matters are settled. Leave judgment to the mark. If there's going to be any changes, let me know in advance. But other than that, Mr. Ofana, in fact, both of you, if you should be ready to take the first appeal on the 17th.
My Lord, we'll prepare for that.
I'm sure. Mr. Campbell.
Today. And we look forward to seeing you on the 17th.
I thought you said you look forward to seeing me in New York.
And then I'm sure I'll take Mr. Nancy for a break.
Oh, certainly. I'm sure you're looking forward to that.
On Twitter,
Gentlemen, the notices will come out up to the day of convening in New York. What will be between that period of time. But don't worry, you leave the draft notice. So you know that it's around the corner. You see, you're not defending coincidence. You're very excited about this trip.
The Cowboys is not going to New York.
All right. May I just extend thanks to all council, the file and local submissions. As you can see, without your assistance, maybe have to be writing it, so it's huge. So I'm grateful to all of you for the assistance given in file and local submissions, which obviously mentioned relevant authorities, so it is easier slightly to get it done quickly. So similarly, we're looking to do the same thing when it comes to closing addresses. Alright, so please bear that in mind. Alright? So we'll join in the to the 17th of March. And then we shall all see in New York.
Which one? This one now. Don't fund my business and then you see. No. Yeah,
Okay. You're welcome to TDN. We've just done with the just concluded ruling on the matter between the states versus Saiduna Law, Dr. Samura Kamara, and 4 others. Of course, as you may know, you've been watching the ruling live, and sitting has been postponed to the 17th of March as they got to visit the US. New York, the Chancery Building, to gather some facts as in the way of locust before the sitting on the 17th of March 2023. So stay glued as we'll be bringing you the facts on this particular matter. Thank you for staying with us. Hope to see you back.